So this video is part 7 of my read-through of the documents for the civil case between David Robertson and Daniel Rodney against Ryan Upchurch. If you've missed the other videos that I did for this, I will link them below, and I will also link the playlist for this particular series below also. I will also add the link for the playlist for the series that I'm currently working on, where I am looking at statements made by law enforcement in relation to Kiely's case. In terms of that series, I won't be doing an additional video for that today because I want to do a series of 3 videos looking at the 3 days of court relating to the Delphi case. So basically my summary and explanation and my thoughts on what has gone down in court over the past 2 days, and then also the 3rd day, which I believe is still in session perhaps at the time of me recording this. So keep an eye out for that. I will be covering day 1. I'll be going through day 1 today and hopefully getting a video for that out later today. Anyway, let's jump in and take a look at more of this document. Okay, so before we launch into this section, we need to look at what is meant by defamation per se. So this is a definition that has been put out by a law firm. So we know that it is fairly accurate. Well, it should be entirely accurate. So it's talking about oral defamation. In some cases, a false statement is considered so inherently harmful that it is considered defamation per se, meaning it is presumed to be damaging to a person's reputation without any additional proof of harm. So it's basically saying that when someone just says something that is so bad that it shows someone in a particularly bad light, then that is defamation per se. If it is something that sounds like it is really damaging to a person's reputation, they don't have to prove that they have had any form of harm from people saying that, because it is so extreme what has been said that it is pretty much a given that it will have caused harm. So section 2, defamation per se as under California law. Paragraph 138, plaintiffs incorporate all the above paragraphs. And we know that Ryan's response will be that he incorporates all the above paragraphs. So we'll go straight to 139. For the same reasons, Upchurch may be held liable under California law and alternatively Tennessee law for defamation. He may be held liable under California law for defamation per se. So the response to that is that it is a legal conclusion to which no answer is required, and then to the extent an answer is required, Mr. Upchurch denies the remaining allegations in paragraph 139. Paragraph 140. Upchurch's false comments accusing plaintiffs of participating in a GoFundMe scam falsely accuse plaintiffs of committing acts of moral turpitude, including fraud. And the response to paragraph 140. Paragraph 140 contains a legal conclusion to which no answer is required. To the extent that an answer is required, Mr. Upchurch denies the allegations contained in paragraph 140. Okay, while I'm trying my hardest to be neutral in going through these documents, I have to confess that having just pre-read this paragraph, I did snort because it does sound a little bit insane. So paragraph 141. Upchurch's false comments accusing plaintiffs of participation in a GoFundMe scam while pretending to be Kiely Rodni's family, while in Upchurch's twisted telling, in fact belonging to the family of Kelly Ross, falsely accuse plaintiffs of crimes of moral turpitude. And the standard answer contains a legal conclusion, no answer required. Mr. Upchurch denies the allegations contained in paragraph 141. For those reasons, Upchurch may be held liable under California Civil Code 46. So, just looking at Section 46 of California Code of Civil Procedure, it says it defines slander as false and unprivileged publication, orally uttered, and also communications by radio or any mechanical or other means that does one or more of the following: charges any person with crime, which pretty much sums it up there. They are saying that under this civil code, it is slander because Upchurch accused them of a crime. And it talks about the means of publication by radio or any mechanical or other means. So basically, because he has said it on the internet, that is still orally uttered, it is still a publication, and because they have accused him of a crime, then that is defined as slander. And the standard response from Upchurch is that it is a legal conclusion, and to the extent where an answer is required, it is denied. So paragraph 143 is another point of law. Plaintiff specifically avers that California's anti-SLAPP law has no application in the Middle District of Tennessee, as Judge Richardson held in Lampo Group LLC versus PAFRA 2019. So that's there stating a precedent, and let's find out what anti-SLAPP law is. So the anti-SLAPP law is basically a California law which protects the petition and free speech rights of all Californians. So it's a law that is designed to protect people's free speech, but what they're saying in this document is that because the case is being tried in Tennessee, that law does not apply. And for that you have the standard response yet again, contains a legal conclusion to which no answer is required. To the extent an answer is required, Upchurch is without knowledge or information to form a belief, and therefore the allegation is denied. Now, I'm no lawyer, and I don't know what is required in terms of this particular document, which is in answer to the complaint, but I would have thought that part of that response should have referred to an equivalent Tennessee law, because if they're saying, well, this anti-SLAPP law doesn't apply because this is not being tried in California, then wouldn't the response be, okay, but this law from Tennessee applies? So section 3 refers to false light invasion of privacy. So let's have a look at what that means first. So the definition here: false light is publicity that unreasonably places someone in a false light before the public. False light involves misleading depictions that create false impressions of victims. So basically making up stories that aren't true about someone, which give people a false impression of those people. Obviously, it would be giving people a negative impression, because otherwise you're not going to be taking any kind of legal action. So that's where I guess unreasonably comes into play. Publicity that unreasonably places someone in a false light. So basically it's talking about making up bullshit about someone that is putting them in a bad light and creating false impressions of them. So paragraph 144 is the standard one. Plaintiff incorporates all above paragraphs, and we know that that will say the same for Upchurch. So we'll skip on to paragraph 145. For the same reasons that Upchurch may be held liable for defamation, he may be held liable for false light invasion of privacy. So the response for 145 and 146 is the same. It contains a legal conclusion to which no answer is required. To the extent an answer is required, Mr. Upchurch denies the allegations. So paragraph 146, which we already know Upchurch has said denied. Upchurch's false statements concerning the plaintiffs place them in a false light which would be highly offensive to a reasonable person. Paragraph 147. It would be highly offensive to a reasonable person to be falsely accused of participating in a scam to profit from GoFundMe. So then Upchurch's response to 147, and we'll look at 148 and 149 at the same time because the response is the same. Upchurch is without knowledge or information sufficient to form a belief as to the allegation contained in paragraph 147 or 48, 149, which is therefore denied. So we'll read through 148 and 149 and see what he's talking about there. So this is kind of further clarifying the point in hand. 148. It would be highly offensive to a reasonable person to be falsely accused of having misrepresented themselves and their identities, lying about who they are and who their loved ones are. And paragraph 149. It would be highly offensive to a reasonable person to be accused of being fake and not real while grieving the tragic death of a loved one whom Upchurch also referred to as a bullshit person, fake and not real. Paragraph 150. It would be highly offensive to a reasonable person to be called fake and not real in the days after their daughter/granddaughter suffered a tragic fatal accident. So the response is the same for paragraph 150 and paragraph 151. Essentially, he is denying the allegations. So let's move on and look at paragraph 151 and 152. So paragraph 151. Upchurch acted with reckless disregard for the truth of these statements as described above. And then paragraph 152. In fact, Upchurch himself appeared to understand the statements were false, as he had previously expressed condolences to Kiely's mum in a video published August 22nd, before later declaring Kiely's mum is not real in a video published September 3rd. And mixing it up a little bit on Ryan's behalf, 152, Mr. Upchurch denies he understood the statements were false. Mr. Upchurch admits the remaining allegations contained in paragraph 152 of the first amended complaint. So he's basically admitting that he had expressed condolences to Kiely's mum in one video, and then in another video said that Kiely's mum is not real. Section 4. Intentional infliction of emotional distress. So paragraph 153 is standard. Plaintiffs incorporate all above paragraphs, so Ryan's will be the same. Paragraph 154. As described above, Upchurch's conduct in uploading his defamatory videos was intentional, and he acted with reckless disregard for the falsity of his defamatory statements. So for both 154 and 155 you have Mr. Upchurch denies the allegation contained in that particular paragraph. So for paragraph 155, Upchurch chose to target members of a grieving family who only days earlier had learned the tragic news that their 16-year-old daughter and granddaughter had died in a fatal accident. So he is putting denied for that. Paragraph 156. In espousing his false claims, Upchurch capitalised on the media attention the Kiely Rodni disappearance had attracted to promote his own music and capture streaming revenue from YouTube views. Ryan's response: Mr. Upchurch denies the allegations contained in paragraph 156. Paragraph 157. In fact, Upchurch openly bragged in the comments to one of these videos about making money from the Kiely Rodni case, stating, "I'm making an insane amount of money." So the response here, Upchurch denies the allegation that he admitted making money from the Kiely Rodni case. Mr. Upchurch admits he stated, "I'm making an insane amount of money," but denies he was referring to any income from the Kiely Rodni case. Mr. Upchurch was referring to his music streaming revenue, not revenue from YouTube views. Paragraph 158. Upchurch directed his loyal band of followers, the Creek Squad, to search for Kiely Rodni's car. He then uploaded a video claiming to have discovered the car at the home of Daniel Rodni. As a result of these actions, Daniel Rodni was subjected to an invasion of his privacy and personal security. So here you have Mr. Upchurch admits that he uploaded a video of what he believes to have been Kiely Rodni's car at the time of the video, but he denies the remaining allegations. Paragraph 159. Upchurch's conduct in belittling a grieving family, accusing them of essentially being actors, faking their loved one's death to profit from a scam, to profit from GoFundMe, was outrageous conduct that no civilised society should tolerate. And the response being Upchurch denies the allegations. Paragraph 160. As a result of Upchurch's videos and statements, plaintiffs have suffered serious mental injury, each seeking therapy for psychological injury specifically attributable, as documented in the medical records, to the conduct of Ryan Upchurch. So Ryan's response here is Mr. Upchurch denies that the plaintiff suffered any damage attributable to his actions, and then he is without knowledge or information sufficient to form a belief as to the remaining allegations, which are therefore denied. Okay, so section 5, negligent infliction of emotional distress. Paragraph 161, plaintiff incorporates all above paragraphs, which of course will be the same for Upchurch. Paragraph 162, for reasons stated above, Upchurch may be held liable for negligent infliction of emotional distress. And you have the standard response from Upchurch for 162 and 163. Mr. Upchurch denies the allegations contained in paragraph 162 and paragraph 163. So let's look at 163. As a result of Upchurch's video publications and false statements, plaintiffs suffered serious mental injury as described above. So section 6 is damages and choice of law. Paragraph 164, which is the standard one, plaintiff incorporates all above paragraphs, which will be the same on the Upchurch document. So straight on to paragraph 165. Plaintiffs specifically aver that the law of California, with respect to the substantive causes of action, remedies and damages, should apply to this action as plaintiffs reside in California. All injuries complained occurred in California, and all treatment for such injuries occurred in California. Now, I'm a little bit confused here. Can you actually do that? In a previous paragraph, they said that the laws with relation to free speech, the California laws relating to free speech, couldn't apply because the case was actually in Tennessee. And now they're turning around and saying that the California laws in relation to damages and injury should apply because they live in California. I can see that there is a bit of a difference in that on one hand they're saying that the actions occurred in Tennessee but the damage occurred in California. But is it still... It seems like they're trying to cherry pick the laws. It could be just perfectly fine, I'm not sure. So you have the standard Upchurch response to that. Paragraph 165 contains a legal conclusion to which no answer is required. To the extent an answer is required, Mr. Upchurch denies the allegations. Paragraph 166. The parties have no relationship with each other except through the transmission of Upchurch's YouTube videos, which plaintiffs were made aware of and viewed in California. So you have Mr. Upchurch admits the allegations that the parties have no relationship with each other. He is, however, without knowledge or information sufficient to form belief as to the remaining allegations contained in paragraph 166. So he's saying that he doesn't know if the plaintiffs were made aware of the videos and if they viewed them in California. So paragraph 167. California thus has the most significant relationship to the parties and occurrence at issue, and California's substantive law should apply. Which goes back to how come the freedom of speech law then does not apply. So the response to 167 and also 168. This contains a legal conclusion to which no answer is required. To the extent that an answer is required, Mr. Upchurch denies the allegations contained in paragraph 167 and 168. So looking at 168 and 169. Paragraph 168. Plaintiffs pray for a recovery of all compensatory damages available under the laws of California or alternatively Tennessee, including damages to their reputation, financial losses, emotional distress and punitive damages based on Upchurch's outrageous, intentional, reckless and conscious, shocking, tortuous actions. And paragraph 169, plaintiff prays for a jury to try this action. And for 169, you have the bit about it being containing a legal conclusion to which no answer is required. To the extent that an answer is required, Mr. Upchurch prays for a jury to try this action. So he's saying he's more than willing for this whole thing to go before a jury. Now, the final section is only on Upchurch's document, and that is his affirmative defence. As for his affirmative defences, Mr. Upchurch states and asserts as follows. First affirmative defence: apportionment of fault damages. Mr. Upchurch incorporates his responses contained in the preceding paragraphs, which is standard. Mr. Upchurch asserts the affirmative defence of apportionment of fault damages. I realise this video is starting to become quite lengthy, but I'm going to try and push on and get through the entire section of this part, because then that will actually bring us to the end of the entire suit. So, paragraph 3. The matter of Kiely Rodni's disappearance was and is an issue of tremendous public interest and concern. Paragraph 4. Before, during and after the publications of Mr. Upchurch's statements, multiple other parties made similar statements, proposed theories, and amassed hundreds of thousands of views of said publications. Paragraph 5. Those parties, non-party publishers, identified primarily by their YouTube usernames include, but are not limited to, Melvin Cedino, aka Icked Mel, Zavgirl, Plunder, Chronicles of Olivia, Harsh Reality, Reporter Room, The Behaviour Panel, Oxyopia, Christina Randall, and many others. Paragraph 6. Each one of those YouTubers made statements and posted videos containing statements and theories regarding the disappearance of Kiely Rodni, calling into question Ms. Rodni's friends and family members and others as potential suspects, exposing the family lodge, questioning the circumstances surrounding Ms. Rodni's disappearance, promoting theories of foul play, and discussing whether Ms. Rodni was missing, dead or real. Paragraph 7. Though Mr. Upchurch disputes his liability for each claim set forth by plaintiffs, should Mr. Upchurch be found to be liable for his statements, any damages stemming therefore from cannot be solely attributed to him, as separate wrongs done by an independent agent cannot be joined together to increase the responsibility of one of the wrongdoers. Paragraph 8. Such statements set forth by the non-party publishers are equally greater or in part responsible for any damages incurred by plaintiffs. So they're basically saying that any damages incurred by the Rodni and Robertson families should also be attributed to all the many other creators who put out content. Paragraph 9. Thus, any damage award made in favour of the plaintiffs must be divided between the responsible parties in relationship to their respective amount of fault. In other words, he's saying, well, if you're going to sue me, and if there are damages awarded, then the other creators should be made to pay also. Second affirmative defence, privileged conduct. Paragraph 10. Mr. Upchurch incorporates his responses contained in the preceding paragraphs. Paragraph 11. Mr. Upchurch asserts the affirmative defence of privileged conduct. So when it comes to talking about privilege in legal terms, I couldn't specifically find privileged conduct, but this is the closest I could find, and it says qualified privilege is available as a defence to a defamation action in circumstances where the publisher had a legal, social or moral duty or interest to make the statement. So for that, he's saying that he had a social interest, I believe, in making the statements that he did. So he's using that as part of his defence. It is a social interest. In other words, he's basically saying there was a lot of interest in Kiely's case, and there were people still trying to wrap their head around Kiely's case. So he was putting out this information because it was of social interest. So with that in mind, paragraph 12, Mr. Upchurch cannot be held liable because his speech was privileged and thus permissible. Paragraph 13, Mr. Upchurch was exercising the legal right as an American citizen, as protected under the First Amendment of the United States Constitution, to comment and critique on matters of public concern. The reported mysterious disappearance of a teenager, Kiely Rodni. So that is what he's saying, what he's referring to in terms of privileged conduct. So he's saying that the Constitution allows him to do that. Paragraph 14. Mr. Upchurch's speech was lawful and consistent with community standards relevant to concerned citizens on matters of crime. Paragraph 15. Mr. Upchurch had a good faith belief that he had a legal right to engage in this speech. Paragraph 16. Thus, Mr. Upchurch's speech was privileged and he cannot be found liable. And then we have third affirmative defence, opinion. Paragraph 17. Mr. Upchurch incorporates his responses, blah blah blah. Paragraph 18. Mr. Upchurch asserts the affirmative defence of opinion. Paragraph 19. Statements that are opinions are afforded certain protection under the First Amendment of the United States Constitution. Paragraph 20. Mr. Upchurch's statements could not have been found by the average listener, given the language and the context surrounding Mr. Upchurch's statements or implications, to be provable assertion of fact. So he's saying that most reasonable people would be able to see that the things that he said could not be proven as fact. Paragraph 21. Mr. Upchurch provided and identified non-defamatory facts underlining his statements. So he's basically saying that he provided facts which he then made speculations on, which he is allowed to do so under the First Amendment of the American Constitution. Paragraph 22. Based on the totality of the circumstances, Mr. Upchurch's statements are statements of protected opinion, and therefore plaintiffs cannot recover. Fourth affirmative defence, failure to state a claim. Paragraph 23. Mr. Upchurch incorporates his responses, blah blah blah. Paragraph 24. Mr. Upchurch asserts the affirmative defence of failure to state a claim upon which relief can be granted. Paragraph 25. Plaintiffs fail to sufficiently set forth facts to plausibly support their causes of action for defamation, defamation per se under California law, false light invasion of privacy, intentional infliction of emotional distress, and negligent infliction of emotional distress against Mr. Upchurch. So he's basically saying that they haven't proven their claim adequately in the documents, so that pretty much makes it null and void according to his defence. And Section 5, Fifth Affirmative Defence, fair comment. Paragraph 26, Mr. Upchurch incorporates his responses. Paragraph 27, Mr. Upchurch asserts the affirmative defence of fair comment. Paragraph 28, Mr. Upchurch's statements are protected by the fair comment defence. Paragraph 29, Mr. Upchurch's statements were made on a matter of public interest, which was the reported mysterious disappearance of a teenager, Kiely Rodni. So he's saying that that is the reason for using the defence of fair comment, because it was public interest, it was something that was being discussed. Paragraph 30. The plaintiffs are limited purpose public figures, and the legal definition of that: a limited purpose public figure is defined as someone who interjects or participates in a public controversy or topic to the point where they are or are trying to influence the outcome of that controversy. Essentially, he's saying that they were participants in the whole situation of Kiely being missing and the search for Kiely, etc., etc. And that outside of that, they are not public figures. I'm not sure if the inference there is also that they are trying to use that limited purpose public figure status to claim defamation, even though outside of Kiely's case they are not known publicly, if that makes sense. Paragraph 31. Mr. Upchurch's statements were not made with malice. Paragraph 32. Mr. Upchurch's comments were published for the bona fide purpose of giving the public the benefit of comments on the matter of public concern. So he's basically saying he was sharing his opinion on something that was of public interest, and that is like his defence, the defence of privilege, basically. Sixth affirmative defence, common interest privilege. So he's saying that because it is a common interest that people were discussing Kiely's case, people were interested in Kiely's case, that allows him the privilege to make these statements. So paragraph 34, we'll skip 33 because we know that that's just the incorporates his responses stuff. Paragraph 34. Mr. Upchurch asserts the affirmative defence of common interest privilege. Paragraph 35. Mr. Upchurch's statements are protected under the common interest privilege in California Civil Code 47C. So that code is pretty explicit. So 47C grants a conditional privilege against defamation to communications made without malice and on subjects of common interest. So paragraph 36, Mr. Upchurch's comments were without malice. Paragraph 37, Mr. Upchurch was interested in the communication or stood in relation to the person interested as to afford a reasonable ground for supporting the motive for the communication to be innocent. Paragraph 38. Mr. Upchurch made these comments to persons interested in the communications, which were other persons interested in the reported disappearance of Ms. Rodni. So he is saying it was common interest privilege. Paragraph 39. The Rodni family and others made a public plea for assistance in the disappearance of Ms. Rodni. Paragraph 40. Mr. Upchurch and others answered that call and began making videos about the reported disappearance of Ms. Rodni. And paragraph 41. Mr. Upchurch had no ill will or malice. So that actually brings us to the end of the two documents. Thanks for bearing with me as we go through these. It's been kind of a long haul, but we finally made it to the end. Please, if you're not subscribed to my channel, please subscribe, hit the like button, and leave a comment below. What are your thoughts, particularly with regards to Ryan's defence that we've just looked at the end here? If you wish to show thanks for the work that I've done here in sharing these documents, there is a link below for Buy Me a Coffee, or there is a barcode here. It would be greatly appreciated, of course. Any support for my channel is greatly appreciated. And once again, thank you to those people who have recently bought me coffees. Every little bit helps.
I've been